Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, Products Liability Theories and Defenses. Let's begin. Products liability is high yield because one injury can support multiple theories. A defective product injures a foreseeable user, and the plaintiff may sue for strict products liability, negligence, breach of warranty, or misrepresentation. The MBE often tests which theory avoids privity, which defect must be proven, what counts as foreseeable misuse, and which defenses reduce or bar recovery. Start with the defendant's role in the distribution chain, then identify the defect, causation, damages, and defenses. Strict products liability applies when a commercial supplier sells or distributes a product in a defective condition unreasonably dangerous to users or consumers. The product reaches the plaintiff without substantial change, and the defect causes physical injury or property damage. The plaintiff need not prove negligence. Strict liability generally applies to manufacturers, wholesalers, retailers, and other commercial sellers in the business of supplying the product. It does not usually apply to casual sellers or service providers. A product may be defective by manufacturing defect, design defect, or warning defect. Manufacturing defect. The product departs from its intended design, even though all possible care was exercised. The product is more dangerous than the properly made version. This is the cleanest strict liability claim. Design defect. The entire product line is challenged. Tests vary. Under the consumer expectation test, the product is defective if it is more dangerous than an ordinary consumer would expect when used in an intended or reasonably foreseeable way. Under the risk-utility test, the product is defective if risks could have been reduced by a reasonable alternative design, and omission of that design makes the product not reasonably safe. Warning defect. The product has non-obvious risks that could be reduced by reasonable warnings or instructions, and the lack of warning makes the product not reasonably safe. A warning must be adequate in content, intensity, and placement. There is generally no duty to warn of obvious dangers or unknowable risks, though obviousness does not always defeat design claims. Causation. The defect must be actual and proximate cause of injury. The plaintiff must show the defect existed when the product left the defendant's control, though circumstantial evidence may suffice. Damages. Strict products liability primarily covers personal injury and property damage. Pure economic loss is usually handled through warranty or contract law rather than tort strict liability. Negligence theory. The plaintiff proves the defendant owed reasonable care in designing, manufacturing, inspecting, warning, or recalling, breached that duty, and caused damages. Any foreseeable plaintiff injured by the product may sue. Unlike strict liability, negligence focuses on the defendant's conduct. Warranty theories. Express warranty arises from affirmations of fact, promises, descriptions, samples, or models that become part of the basis of the bargain. Implied warranty of merchantability requires goods sold by a merchant to be fit for ordinary purposes. Implied warranty of fitness for a particular purpose arises when the seller knows the buyer's particular purpose and the buyer relies on seller's skill or judgment. Warranty claims may allow economic loss and may be affected by notice, disclaimers, limitations, and privity rules. Misrepresentation. A seller who makes a material misrepresentation of fact about a product may be liable when justifiable reliance causes harm. Intentional or negligent misrepresentation may be tested separately. Some product misrepresentation theories impose strict responsibility for public statements. Defenses. Comparative fault generally reduces recovery in strict products liability when the plaintiff's unreasonable conduct contributes to injury. Assumption of risk may reduce or bar recovery depending on the jurisdiction when the plaintiff knew the specific risk and voluntarily encountered it. Product misuse is a defense if the misuse was not reasonably foreseeable. Foreseeable misuse should be designed or warned against. Substantial alteration after sale may cut off liability if it causes the injury and was not reasonably foreseeable. State-of-the-art evidence may matter especially for design and warning claims, but does not usually defeat manufacturing defect if the unit departed from intended design. Disclaimers generally do not eliminate strict tort liability for personal injuries, though they may affect warranty claims. California is a major strict products liability jurisdiction. California recognizes manufacturing, design, and warning defects and applies consumer expectation and risk-benefit concepts in design defect cases. In California design defect litigation, once the plaintiff makes a prima facie showing that the product's design proximately caused injury, the burden may shift to the defendant to show benefits outweigh risks under the risk-benefit test. California generally applies comparative fault principles in strict products liability, reducing recovery for plaintiff fault. California also recognizes that retailers and others in the distribution chain may be strictly liable, even if they did not create the defect. Note: on the MBE, use general majority principles unless the question expressly asks California law. On California essays, mention both consumer expectation and risk-benefit tests when design defect is in play. Trap 1. Suing a casual seller in strict liability. A neighbor's one-time sale of a used lawnmower is not a commercial distribution chain sale. Negligence or warranty may still be considered. Trap 2. Requiring privity for strict liability. Foreseeable users, consumers, and bystanders may recover for physical injury even without contractual privity. Trap 3. Calling every accident a manufacturing defect. If every unit shares the alleged danger, it is a design or warning case, not a manufacturing departure. Trap 4. Ignoring feasible alternative design. Many design questions turn on whether a safer, reasonable alternative existed without destroying utility or imposing disproportionate cost. Trap 5. Letting obvious danger end the analysis. Obvious danger may reduce warning duties, but design may still be defective if risks outweigh utility. Trap 6. Treating misuse as automatic bar. Only unforeseeable misuse is a strong defense. Products must account for reasonably foreseeable misuse. Trap 7. Using warranty disclaimers to defeat tort claims. A disclaimer may limit warranty remedies if valid, but cannot usually waive strict liability for personal injury caused by a defective product. Trap 8. Forgetting learned intermediary. For prescription drugs and medical devices, warnings to the prescribing physician may satisfy the manufacturer's duty because the physician acts as learned intermediary, subject to exceptions. A manufacturing defect question often says one bottle contains a contaminant, one tire has a flawed patch, or one chair collapses because a bolt is missing. Compare the unit to the intended design. If it departed and caused physical injury, strict liability is strong even if the maker used due care. A design defect question says all models have the same rollover tendency, guard emission, or fire risk. Ask whether ordinary consumers would expect the danger and whether a reasonable alternative design would reduce risk without unacceptable cost or loss of utility. A warning question says the product has a hidden risk. Ask whether the risk was known or knowable, whether ordinary users would appreciate it, whether the warning would have changed behavior, and whether the plaintiff used the product foreseeably. A remedies or defense question may insert plaintiff carelessness. Under modern comparative fault, plaintiff negligence usually reduces recovery rather than barring it. But knowingly using a product despite a clear, specific danger or radically altering the product can sharply limit recovery. Attack sequence. Is defendant a commercial supplier? What theory is asserted? Strict liability, negligence, warranty, misrepresentation. What defect type? Manufacturing, design, warning. Did the defect exist at sale and cause physical harm? Is plaintiff a foreseeable user, consumer, or bystander? Consider misuse, alteration, assumption of risk, comparative fault, disclaimers, and economic loss. Exam payoff. Products liability is not one rule. It is a menu. Strict liability focuses on defective product condition, negligence on conduct, warranty on bargain-based assurances, misrepresentation on reliance. The highest scoring answers classify the defect first and then apply defenses theory by theory. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.